The House Financial Services Committee held a hearing yesterday on the future of digital assets. And our first guest is one of the witnesses during that hearing, Prometheum co-CEO Aaron Kaplan. Welcome back, Aaron. Okay, so the focus of that hearing was on the stablecoin bill drafted by House Republicans. Let's first listen to part of your opening statement.
I'm particularly worried that
there is a compliant path forward for crypto in the United States that the SEC has clearly laid out. Those who argue for new laws are simply not willing to comply with existing applicable securities laws and regulations. New legislation is not in the best interest of the investing public or the blockchain industry. Legislative efforts will take years to implement while the American public will continue to operate on reckless, unlawful platforms.
Okay, Aaron. So let's get first your main takeaway from the hearing yesterday and your thoughts on the stablecoin bill for people who are not tuned in.
Thank you for having me. My main takeaways were that the draft market structure bill did not properly protect the investment public. The provisional registration for crypto firms as commodities distributors basically exculpates them from any previous sort of liability to any of their customers. Now, let's take FTX or Binance, for example. Under the bill, if FTX or Binance had registered as a provisional commodities firm, a digital commodities firm, essentially their customers would not have any recourse against those firms once under that provisional registration. So essentially, it basically sacrifices the needs of the public at the expense to the benefit and to the reward of the entities that essentially have not followed the law historically.
So just to be clear again, for people who are not following this in great detail, what exactly are you proposing? So you're quite critical of this bill, but what are you proposing? Are you just proposing the status quo, or are you proposing something, some specific alternative?
Part of the draft market structure bill essentially gives a lot of responsibility for oversight of crypto to the CFTC. And I would argue that the SEC and FINRA are the most capable financial regulators in the world. Combined, they have 8,000 employees. The CFTC and NFA, which is the regulator, and the SRO, combined have 1,300 employees. We saw the dangers to the public when this area is not properly regulated, when there's not proper enforcement mechanisms, when there's not proper oversight. Why not put our most capable financial regulator on this case, or basically, why not apply the most capable financial regulators in order to protect the public here?
But are you sort of arguing that the SEC should just continue doing exactly what it's doing? Or because I feel like that's, a minority opinion in the crypto world, or is there something that the SEC should be doing somewhat differently? Because obviously their current approach is widely controversial in the United States.
Well, Prometheum Capital was just approved as the first special purpose broker-dealer, which basically allows it to compliantly custody digital asset securities under the federal securities laws. Before that, the SEC has laid out compliant frameworks for the trading and custody of digital asset securities. Maybe before Prometheum Capital was approved, people could argue that there were frameworks, but there was not necessarily a path forward because essentially no one was approved under those frameworks. Now that argument is moot. There is regulatory clarity. There is a path forward for crypto in the United States. And basically the way forward is to follow the example that Prometheum Capital and Prometheum ATS have laid out.
So I have to ask, you say, like, look, if the CFTC were in charge of FTX, the customers would have no recourse. But this situation with FTX was that basically they were committing outright fraud and all sorts of issues with commingling funds, things like that. Last I checked, that's just not legal anywhere, regardless if it's the SEC or CFTC or, a real estate brokerage. I as a former real estate broker, as a currently licensed real estate broker, I'll tell you, you commingle funds, you're in a lot of trouble. And that has nothing to do with securities. So the issues regarding that kind of stuff, and also the charges that were brought against Binance, were very severe. And that also had to do with commingling funds. So I don't understand this argument. And if you could perhaps clarify, wouldn't customers still have some recourse involved with FTX, given what they did was fraud, if it had occurred in the United States anyway?
No, essentially, under the draft market structure bill, when someone provisionally registers with the CFTC, basically they're no longer liable for any of their previous actions when they were not registered. Essentially, it sort of presents a force field that prevents any customers from taking recourse against them who were harmed and prevents any regulator for taking action against them off their previous violative conduct. That doesn't seem to make any sense. Essentially rewards entities that have basically violated the law, and it harms their customers who were harmed by those malicious activities.
But that, from my understanding, and you could correct me if I'm wrong, that would involve situations where they did things that were in violation of, let's say, securities regulations. But this is fraud.
But who cares about securities regulations? You violated the law.
Right.
You basically did not follow the law, and essentially you harmed your customers, and as a result, those customers should have recourse against you. Just because you provisionally register with the CFTC doesn't mean that your prior actions that were malicious and harmful to your customers, that you shouldn't be held culpable for them.
So then what's to keep every, I don't know, let's say the Mafia, which doesn't exist if you're watching this and you're in that, it doesn't exist. But what's to keep people from the Mafia, let's say, from registering with the CFTC and saying, well, yeah, we did loan sharking and things like that, but we're registered with the CFTC now. I mean, that also doesn't make sense. They're still liable. I mean, there's tons of people in prison in New Jersey over this, for all sorts of fraud and things like that. I mean, wouldn't they have gotten off if they just registered with the CFTC, according to your argument?
You're conflating two issues. One is when you're issuing financial products to the public that are investing in that product. They're speculating in that product basically with the intention of generating a profit in a common enterprise primarily from the efforts of others. Essentially, those are financial-based activities. Those are financial-based violations if you are not complying with the law there. And what we need is the most stringent framework in order to protect the investing public. What we saw with FTX, when there's not proper oversight, when there's not proper regulatory frameworks, essentially the investing public is going to be harmed. The best way forward is the application of the federal securities laws, which are tried and tested over generations and are literally meant to protect investors.
So the fact that they issued, let's say, I don't know, they commingled funds and they may have issued balance sheets that were false, things like that they basically committed fraud prior. If they had then subsequently registered with the CFTC, you're saying that all that amount of fraud, regardless of what was involved with securities aspects to it, but I'm talking about straight up fraud, straight up felony stuff, all of a sudden gets wiped away just because they registered with the CFTC.
So the bill is not 100% clear. There's still a lot of clarifications that need to occur, but any fraudulent financial related activity, there's an argument that they would not be held liable for that under the provisional registration. Now, beyond that, the question really is how do we best protect the customers? When it comes to FTX, if there had been proper oversight, if they had to do proper reporting, if there had been a mechanism to make sure that they were somehow maintaining levels of compliance, I think we could have avoided a lot of the issues. Obviously, there was outright fraud, but if there had been a mechanism to make sure that they weren't committing fraud and that someone was properly overseeing them, customers would have been protected. And that's what exists when you apply the federal securities laws. You have the SEC and FINRA, which are the most capable financial regulators in the world.
The issuers would then also have to, the issuers of these tokens, et cetera, would also have to do quarterly reports, things like that, which they, again, you're asking them to do things that just don't exist in what they're doing. And so it doesn't necessarily make sense.
You're telling me that a company could raise hundreds of millions of dollars and they have no responsibility to issue any sort of reports or disclosures? Think about it. What you're saying is...
What company issued Bitcoin?
Bitcoin is the only sufficiently decentralized entity. We can say all these nonsense tokens, but the overwhelming majority of smart contract-based network tokens were issued for raising capital with the intention of creating out a network based on the efforts of others, where that network, the price of that asset, the price of that token would increase based on the effort of those individuals to create a value in the common enterprise. There's no getting around this fact. We are fully aware that the overwhelming majority of companies raised capital by issuing a token in order to build out a network where the people who participate in that token had the idea that they would have an increase in value in that asset based on the efforts of those engineers and the developers to develop out that network.
Your industry peers have tried to do exactly what you've done. They've tried to register with regulators. They've come out and said, it's just not possible. We've tried to have conversations. We're not really getting anywhere. Don't you think there are clear regulatory frameworks that are needed for your peers in the industry so that the industry can grow and they can achieve the same thing that you did?
I believe that the peers can follow the same frameworks and the example we've laid out. Essentially, people say, oh, whenever we go into the SEC, we get a Wells notice. They're conflating two concepts. One, you're trying to figure out how to come into compliant. Two is, what about your previous violative conduct? Just because you try to work out how to come into compliance doesn't mean that you basically it exercises or launders all your previous violations.
I want to talk about the Howie Test. During the hearing yesterday, the Financial Services Committee GOP account tweeted that the new bill will reform the Howie Test and clarify what a security or commodity is. How important do you think that is?
I think the reformation of the Howie Test is an attack on the general concepts that underpin the securities laws. The securities laws are based on substance over form. They're based on the economic realities. They look at the reality of the transaction, not the fact that someone declares it's a token and not a security. And basically what the draft market structure bill does, essentially it says that once a company says that they are sufficiently decentralized and there's a declaration of such, they are no longer a security. There is no precedent for a security caterpillar to transform into a non-security butterfly. It hasn't happened. There's no basis for that. And I don't understand why once something is a security, it should not be a security thereafter. The people participating in that asset are literally doing it for the same reason they did in the beginning. They anticipate an increase in the value of that asset based on the people developing out that network to attract more transactions or customers.
Aaron, thank you very much for joining us this morning. That was Prometheum co-CEO and founder Aaron Kaplan.